Well, hey everybody, hello. Here today to talk a little bit for Paralegal 101, and we're on the section on the difference between state and federal courts. Remember, you can always reach me at robdawalt@me.com, and since it's early in the course, here once again I'm going to share, this is what your textbook looks like. I need to get you a copy. It's Joan Hames and Yvonne Eckern are the writers of the book. The problem with these big national books like this is that they're written kind of on a national basis, and generally speaking, I'm thinking that most of you are going to work in Indiana, and so you need to know a little more from the Indiana perspective. So I'm going to kind of give you a little bit of insight, more so than the book does, about the Indiana law. I think this will be useful to you, maybe not even in this course, but throughout life, I'm thinking. The other advantage of this is it's going to be on YouTube. You can look at it anytime you want to on Dawalt lectures. It'd be Para 101, and I think that this would be perhaps number 2 or 3. I'm not exactly sure, but you can just look through there and just review these, and I've had students say that they look at them over and over again, and it's very helpful. So we're going to talk a little bit about the difference between federal and state courts, talk a little about structure first. Remember that the U.S. Constitution is the supreme law of the land. So while each state has a constitution, basically under the 14th Amendment, Equal Protection and Due Process Clause, if any state constitution does not conform with the laws and rules set forth in the U.S. Constitution, then they will be deemed to be improper and wrong and struck down. And that's why so many of these states that do these crazy things on certain specialized rules or laws that they pass that tend to discriminate against other people, such as gays, minorities, blacks, Hispanics, or even abortion rights, things like that, based on the federal law, based on the U.S. Supreme Court cases and the U.S. Constitution. Those cases will not stand. Now, that doesn't mean I agree with them, don't get me wrong. I'm just telling you how the law works. And so when you get into this, then it's Article 3 of the U.S. Constitution invests the judicial power of the United States in a federal court system. Now, it's really kind of vague after that. It really calls for statutory construction, so then the Congress has to pass certain laws. Of course, there is one constitutional federal court, and that is the U.S. Supreme Court. And then it talks about such other lower courts as Congress deems to be necessary. So what ends up happening is that Congress can create lower courts. A good example of this, for a long time, every federal court had a bankruptcy referee. Well, bankruptcy referees then served at the will of the federal judge in that district. And so if he didn't feel like that the bankruptcy referee was doing a good job, then he could move that referee out. Well, later on, Congress passed a new law and said, we're going to elevate all the referees to be independent judges, so they will be also appointed. Now, one of the big things it also says in the Constitution is that all judges in the federal system are appointed for life. So what that means is that you go from a referee, which means you might work 10 years or whatever. Maybe a new judge comes in, for example, and wants to put his friend in as the bankruptcy referee, you're out of a job. Well, now bankruptcy judges are judges for life, just like the federal judges, so they're on more or less an equal plane, even though in a really specialized area, which is bankruptcy. Same thing with Supreme Court justices. Of course, they serve for life. Many of them are like 70 years old when they get appointed, and they serve till they're like 90. And some people question and argue, well, these guys are so old and these ladies are so old, how can they really be working with a clear head when they're like 85 and trying to decide these important questions? You know, and that's a fair question, because When these judges were appointed for life in 1783, life was generally considered to be 35 years, and so your judges were considered pretty old if they were 40, 50, something like that. So been a lot of changes in the way that our society is constructed and the effect that that has on the written word, which is the U.S. Constitution. And so by its very nature, the Constitution, or the effect of the Constitution, does change based upon the demographics and changes within our society. Remember then, Article 3, Section 1, the only real thing it says specifically is that the Supreme Court will be the court for the federal government, and then there'll be such other courts as is created by Congress as they deem necessary. Another thing in the federal system that Congress later, after establishing a series of what we call circuit courts, which were courts where there was a single judge that covered maybe even 2 states or something like that. Well, later on, each of these federal judges were just given a district, and so they were considered a district judge at that time. So what's happened then is they created courts of appeals, which is an intermediate level court that hears appeals from the different federal courts. In Indiana, for example, our Court of Appeals is in Chicago. It's the 7th Circuit. So these are the types of things that have happened over time, that Congress adjusts things. Like I said before, they made this bankruptcy court. They also have a court on international trade and some other issues like that. In addition, judges have what they call magistrate judges, who are more or less their assistant judges in the federal court system. So if you look in your federal court system, then you're going to have a federal judge in your district. You're going to have basically a magistrate perhaps, and you're going to probably have a bankruptcy judge. So me, myself, I'm in the Northern District of Indiana, and there's several judges actually. There's one in Fort Wayne, South Bend, Gary, Lafayette, this type thing. Hammond, I believe. So there's a number of different courthouses and judges around this region. Same way in the south of Indiana, it's a separate district, and so they have their own series of judges down there, Evansville, and places like that. So any kind of a decision that's made in a federal court can be appealed to the Court of Appeals, which would be the one that's in their district or in their region, which ours would be 7. Michigan's is different, Ohio's different. Illinois is the same as Indiana, along with Wisconsin. Here's the thing about the Court of Appeals and how it's different than the U.S. Supreme Court, and that is that they basically will hear just about every appeal that you file. Now, they may not do anything with it. You may not be satisfied with the outcome, but they, at the very least, do listen to the appeal. The Supreme Court, generally speaking, has broad power to decide which cases that they hear. And they receive thousands of petitions to hear different kinds of appeals. But the court is under no obligation to hear those cases. And so probably the U.S. Supreme Court, which is the final arbiter of federal questions of law, hears between 100 and 300 cases a year out of these thousands of cases. And so they have clerks and different people that comb through these cases and try to decide which ones that they may hear or they may not hear. Well, what I'm going to do is I'm going to diagram for you just real quickly how this works then. And this I'm putting U.S. here, and then and I'm not going to put exact numbers on here, but I'm going to put kind of how this works. And this is the federal system, okay? And this is just showing that these are all courts of appeals. And that's just, so a court of appeals, 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 okay? I'm not being exact on the numbers. You want to check that out, you can on your own. And so this is the Supreme Court. They can choose to or not to hear cases so that they make these decisions. And then what you have under here, you actually have, like in our case that I just said, you'll have district courts. And that's, say there's Indiana, Illinois, and Wisconsin, okay? And then Ohio's going to have one too. And that's like Ohio, Kentucky, you know, somebody else. So each one is going to have district courts in each area, and it's hard to draw on a thing like this, just offhand, so sorry, apologize. But so as you see, then in other words, there is a line of appeal here then, and what I'm going to do is show you how this works then. So basically, you kind of get the idea. Well, what ends up happening, let's say that there's a case here filed in California, which is in the 9th District Court of Appeals. So this is California, and so they want to appeal it. Well, then they've got to go to here first, 9th District, okay? And then we put this one as 7, okay? So the numbering's all off, everything, but just try to give you the idea of how this works. So you go to the 9th District Court of Appeals, they shoot you down, okay? Or say they decide they're in agreement that the trial court treated you wrong. District court made a mistake. And so a lot of times that's in a summary judgment. They say, no, this should have gone to trial. So, well, then the other side says, no, the summary judgment should have been approved. So basically then their next step is up here. But the judge up in the Supreme Court, they may say, well, no, we don't have enough people. This isn't important. We can't deal with this. It's just too much to deal with. So this is a different kind of a setup than Indiana. Now what I'm going to do is I'm going to show you Indiana. Now Indiana, just by its nature, is subordinate to the federal system that I just showed you. But they do draw much of their power and respect. They get respect from the federal system. They're not going to upset these different courts without good reason. Okay, so this is a court of appeals. Like 1, 2, 3, 4. These are all courts of appeals. Okay, but look at how I've got this now. See how there's this line that goes over and it branches, but then it comes back together. Okay, and there's a reason for that. And then this is a line, and there's actually 92 separate court districts on here. And every county, like Indianapolis, for example, they're going to have like whoop, like that, see. So, you know, my hometown is Marion, and it's got like 4 courts, okay? And then below that even they have city courts, and so they have 2 city courts, okay? And so appeals from city court go to the circuit or superior court, and then when they come up to here, what I'm showing you is, okay, they go up, up. But when they come up to here, this is like a blind draw, okay? You don't know what court of appeals you're going to get when you file an appeal. You just file a court of appeals, and then it just goes up here and somebody gets it. And then from here, generally speaking, you do have a right to appeal to the Indiana Supreme Court, okay? So in structure then, it's just a little bit different in that you have a little different way of submitting cases to court and then to appeal, okay? So that's a major difference, I think, is this just goes into a pool, appeal goes into a pool, and then they just assign it to one of the courts, depending on which court is the busiest. And so that's how that's done. I mean, is that good? Is it bad? I don't know. But it's different. Another thing I'm going to talk to you about real quickly is federal judges. Like I said, what did I say a minute ago? They're all for life. They're appointed for life. Who are they appointed by? They're appointed by the Pres and approved by Congress, okay? So appointed by the President, approved by Congress. Now, the political system has gotten so out of hand now today that the President comes in, makes all these appointments. You know, people grow old, they die. Well, the President wants to appoint, let's say in this case now, Democrats to be federal judges, because he thinks that they'll take a more active role in trying to make things better for people. Well, the Republican president, when he was in there, he wants to put conservatives in there that'll say, well, no, let's slow down these changes. We don't need to do anything rash. And so what happens is, the president makes these nominations, is what it's called, or appointments, but by nomination. And then Congress has to approve it, okay? Well, the problem is that, especially lately, the last couple Democrat presidents, they get trapped here. These positions never get filled. So therefore, the job never gets done. So the judges are overtaxed. They've got too much to do because of these lifetime appointments. Now, lifetime appointments were put in to avoid politics. What does that sound like? Is that avoiding politics? No. And so that's not that good of a setup. And the other problem is that you've got guys that'll come in here that'll be judges for life, and they do get Alzheimer's disease or something in their while they're still alive, but they like getting that big check every year. So it's hard to get them out of there once that they're appointed. So there's some advantages and disadvantages. They never have to stand for election. They never get into the petty politics of having to run in front of the voters. But there's other forms of politics in just about every system. Now in Indiana, and one thing that the notes that I have here says is that this varies a lot from state to state. I hope you can read this. In Indiana, this is all by election. This is a political election of the trial judges. Okay, trial judges are elected by election every 6 years. Okay, so judges, 6 years, and they have to stand as a Republican or a Democrat for election. Okay, now one thing is the appellate judges are actually put into office by the legislature and the governor, and then they have to stand for election. And the only thing is, it's just like yes or no. Do we keep this judge? Yes or no? Yes or no. And that's what they call a form of modified Missouri plan. Modified Missouri plan. So the Indiana trial judges are elected under the old way, which is trial judges elected by political process involving political parties, okay? In the appellate level, though, the Supreme Court judges and the appellate court judges get appointed by the legislature through the governor, and the only issue is, are they doing a good job, yes or no? If they're not doing a good job, out they go, and so then the governor puts another name up there and they vote on it. Now, how often does someone get a vote that says no? To my knowledge, it's never happened. I don't think it's ever happened that an appellate judge has been shot down, okay? So basically then the next thing is, I want to just share with you that I lived in Ohio for a while. Ohio's system is called non-political election, okay? And that means that all judges run, but they cannot name a political party, okay? And this is another form of what they call modified Missouri plan, okay? And if you really want to know what the Missouri plan is, you need to really dig into that a little bit more. Just Google on Missouri plan and find out, you know, what the true Missouri plan is. Plus, there's a lot of different. Every state has a different type of setup for finding and appointing judges, and it's either by political election, non-political election, or the true Missouri plan, which is appointment followed by yes, no elections every so many years. Do we want to keep this judge or not? You know, generally speaking, once they're in, they're in. But Ohio, you cannot name your political party. Now, let me tell you, when I lived there, if you were active in political politics, you would get a little cheat sheet from the different political parties, and they would say, well, we like this judge. Okay, he's one of us. Wink, wink. Okay, so here again, when we say non-political, really nothing is non-political. But once again, once these guys get in, then whenever they run, they're running in supposedly a non-political type of arena, not where you've got Republicans overtly supporting them with campaign contributions and so forth. This has all got to be kind of on the slide, person to person, not party to person. So that's a little difference. But if you notice what I'm saying, really, there's not that much difference in all of these, because if it's appointment for life and the Congress isn't going to work with the president, then nothing's going to get done, and so you're not going to have any federal judges. And then if it's election, then it's real political here, but on this side, it says it's non-political, but it really is political. Okay, so really there's not that much difference. I mean, in the written word there is a difference, but what I'm saying is in practice there's not that much difference. Okay, so another thing I want to point out is there are also specialized courts in states, just like there are in the federal government. Now, states do not have bankruptcy judges, but they do have probate courts that handle wills. They do have juvenile courts that handle juvenile matters. I worked in a juvenile court as a referee. They have family courts. I worked in a family court in Ohio as a probation officer, and those courts handle all the juvenile matters, plus the divorces, plus the paternities. Now, the juvenile system we have in Indiana, the juvenile court handles delinquency, neglect, abuse, and paternity, all those. So pretty much the same, except no divorce in Indiana, divorce in Ohio. So that's the difference. Well, in every case, parties that are dissatisfied then can appeal to a court of appeals, and then in most cases, if they're not happy with the decision of the appeals court, they can go on and appeal to the state Supreme Court. Now, you can petition the U.S. Supreme Court after the final decision if you feel like there is a federal constitutional question in your case, but you just cannot appeal just the average garden variety case. Everybody tries to structure their case to say that it is a constitutional question of federal parameter, but it's not that significant most of the time, and the judges usually shoot you down in the Supreme Court. So it says only certain states